Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hello, everyone. Welcome to another episode of the Empowering Plans Podcast. I'm your host for today. You know me as Brady, Bizarro, one of the attorneys here in PGC. And joining me is Brian O'Hara. Say hello, Brian.
Hello, Brian.
Perfect. Perfection. Brian's another attorney of ours in provider relations here at the FIA Group. And he and I are going to meet to talk today about one of the most exciting topics I could possibly think of. And that is something called Chevron. It's kind of like a Chevy, but not anywhere near as cool. I can't even think of a joke that Ron would make that's as fun, but it's a really important topic. You may have seen a case about it recently. It was heard in the Supreme Court, and it has big implications. So what we want to do today is go over what this is about, what you should know, how it could impact the healthcare industry, and more broadly speaking, regulatory agencies throughout the government, because it's a really important case. So this is probably one of those podcasts where we're going to go in some of the weeds on the legal arguments. Some people may not find that entertaining. I think you should. We'll try and keep it our best, though, to keep it lighthearted and not too dull.
Sounds like we're going to take the magic school bus back to law school a little bit today.
Right, yeah. Yeah, it's going to drum up some nightmares and some memories for me, mostly bad ones, because it's really one of those cases that you have to cover in constitutional law and other courses, administrative law and more, and healthcare law as well. So with that said, we'll jump in. What is Chevron? Chevron Deference is a legal principle that was basically announced in the 80s in response to basically a bunch of federal agencies that were taking actions to supplement or fill in gaps in legislation. So oftentimes when a bill is passed in Congress, which honestly these days feels like there's fewer bills now than ever, but oftentimes when bills are passed, they're not perfect, right? There's often gaps in them. Congress can't think of every possible eventuality or intention that they may have for a certain policy, right? So they usually enact the law, and then they'll delegate authority to administrative agencies, whether they be departments, agencies within departments. So we're talking about HHS or CMS, the FDA, the CDC, et cetera. And those agencies will take action to fill in some of the gaps. And over time, especially where the legislation at issue is particularly missing things like details, the agencies often have to do a lot to fill in the gaps. And you have parties that come to court and say, hey, we think this agency's gone beyond their authority in interpreting the statute, and they push back against the rules. And so the Chevron case in the 80s, deciding that case was against the EPA, I believe was the agency involved there. But the court has basically said that if a statute is ambiguous, either because the language itself is unclear or there is no language, then the court said that Congress has intended to delegate the authority to the agencies to fill those gaps. And as long as the agencies are acting reasonably within their expertise, the court should defer to those agencies in terms of what they're deciding. So the court shouldn't step in and make a decision for the agency. They should defer to reasonable agency actions. And that simple case has really spawned a ton of litigation and agency action. It's, in many people's view, led to a huge increase in size of the bureaucracy of the administrative state. And so this case has come up and been cited many times. And in law school, you learn about it in the context of administrative law to see what is the authority that agencies have to make decisions, right? So why this case is super important, there's a couple of cases that came to the Supreme Court and just had oral arguments about them a couple of weeks ago. And they're important because it looks like the court is going to change or completely strip away this Chevron deference. And the reason for that is because there are members of the court now who historically have taken a negative view of increasing agency power. And so they view the Chevron doctrine, for the most part, some of the justices, or perhaps a majority of them, as having gone too far and allowed agencies to just go beyond their authority and enact rules that go way beyond congressional intent. So Brian, do you recall in law school, did you hear about the Chevron case? What did you learn about it? What do you want to tell the listeners about your fun experiences with Chevron?
Of course, like you said, it impacts many different areas of the law. So you hear about it quite a lot in law school. I do remember taking an administrative law class many years ago, over a decade ago. And certainly Chevron was probably the most important seminal case in that class. And, any kind of changes to Chevron deference will certainly have wide-ranging effects.
Yeah, absolutely. So what happened in these two cases here is important, I think, to dig in, because you can kind of get an example of why the Chevron doctrine is controversial. So these two cases both involve a regulation that was put forth by an agency of the Commerce Department. And the regulation required fishing vessels to carry federal observers on the vessels to monitor compliance with federal fishing regulations. So literally, you had to put a person on your vessel when you went out to sea to make sure that you were following the rules. So the statute permits the agency of the Commerce Department to require the owners of certain vessels to pay the salaries of these observers. And the salaries can be pretty hefty, up to 20% of the vessel's revenues. So the statute, though, did not specify all vessels that were impacted, right? So it was a little bit ambiguous about which kind of vessels were subject and what exactly the payment amount should be. It wasn't really clear. So a final rule that was published in 2020 permitted the agency to impose salary requirements on vessels that were not enumerated in the statute. So you had vessels that were not listed in the statute, but nonetheless, this agency said, we're going to subject these vessels to this rule. And so you had a bunch of family-owned and operated vessels going out to sea, right, that suddenly had to pay for federal observers to be on the ship with them. And this is obviously very burdensome. And so in one of the cases, 4 families sued and said that the administrative agency in this case overstepped and they challenged the rule. And the district court in that case applied Chevron deference, and the majority said that the agency could do this under the Chevron deference principle, that it was a reasonable interpretation of the statute. There was a dissent, of course, as there often is in these kinds of cases, saying that this was not a reasonable interpretation, that Congress did not intend for all vessels to be subject to paying salaries in this case. And as you might imagine, it was appealed up to the Supreme Court, which is where we heard the oral argument there. The other case is very similar in that Chevron was being relied upon there as a justification for why the agency took this action. And in the other case, the First Circuit, which is based here in Boston, was even more in favor of the Chevron doctrine and said it was certainly reasonable what the agency did. So those two cases were appealed up to the Supreme Court, and the Supreme Court took the two cases together. And as some observers have weighed in on and said, the court didn't have to address the Chevron question, but it decided that it would. And that is why a lot of legal observers think that they're going to make some change to Chevron in light of these cases, because it has far more reaching implications than just, these relatively minor regulations about seafaring vessels. So that's the background of the case here. When we talk about what issues are being considered and why it's important, so effectively, if the court overturns the Chevron doctrine, right, one issue is that it could open up the floodgates to thousands of litigants who previously had actions decided, right, based on deference to agencies. If suddenly the court is going to say, no, you don't have to defer, or we're not going to defer to agency interpretations, we're going to, utilize our own authority under Article 3 and use our judicial function to see if what is being done makes sense. If that's the case, then you could have a ton of cases flooding the courts. So that's one consideration. And then without Chevron, fundamentally, what does this mean for courts? Are they going to be policymakers? Are they going to be asked to step in when there's an ambiguity in the law and where you would normally have an agency fill in the gap? Is the court the best entity to make this decision? Are they experts in these fields? Probably not, right? So that's one consideration. So it's really a balancing test here. The last two things here is, what do we even mean by ambiguity? One person may see an ambiguity where another one doesn't. So the court's got to consider if they want to define or try and define the word ambiguity a bit better in their holding and whatever they decide here. And then finally here, does Chevron itself, does it interfere with the concept of judicial review? In other words, does this deference doctrine, which effectively tells a court to just defer to an agency that was reasonable, does that in and of itself violate the Constitution, which requires courts to perform judicial review of agency actions? Those are the considerations that they're going to be looking into. I don't know what you think, Brian. My sense of things is that I don't think they'll throw the whole thing out. They could, but I think that they're going to severely restrict the application of Chevron. I'm not sure if you had a sense of what you thought.
I agree. Frankly, it's not terribly surprising that we're seeing these kinds of challenges. During his time in office, former President Trump appointed over 230 federal judges in just one term. That includes 3 Supreme Court justices, which gave the Supreme Court a significant conservative majority. as you mentioned, there's people on the bench now that are far more suspect of federal powers and often seek to rein in federal authority. A lot of these conservative judges often view federal agencies as too powerful, lacking enough oversight without enough checks and balances to their authority. And frankly, as we all know, the Supreme Court has not been shy about overturning landmark decisions. So it wouldn't shock me to see the court maybe narrow the scope in which agencies receive deference, though I agree with you that it would surprise me if they overturned it entirely, just because of, if for nothing else, the Pandora's box that would be opened by removing this deference that's been in place for decades.
Yeah, I think you're right that this court is definitely not shy about completely removing precedent that's 30, 40 years old in certain cases. So
Yeah.
I guess I wouldn't be terribly shocked, but this really could have an impact in our space here in the healthcare space. So I found some data here saying, generally speaking, federal agencies currently prevail in about 70% of challenges to their rules under Chevron. And that's from the Brennan Center for Justice. That's pretty high. That's a pretty good rate. I bet you that rate would go significantly down if Chevron is severely, reduced in scope or entirely overturned, because again, that would mean that courts no longer have to defer to agency interpretation and action. And so you'll see a flood of cases. So there's a couple of agencies, right, that come to my mind immediately, obviously. And again, when I say agency, we're referring to the broader department, cabinet level departments as well here. So HHS is one of those, right? You have CMS, you have the FDA, you have the FTC, you have the CDC, you have the DOL. I mean, there's tons of different agencies here, and they're constantly publishing rules. One that comes to mind immediately is under the Inflation Reduction Act, there was a provision to allow Medicare to negotiate drug pricing, right? That's going into effect in a few years. And it's a very important law. And there's rules being written up that CMS will draft and will publish and try to enforce. And I guarantee you, if Chevron is entirely removed or reduced in scope, that you'll see tons of lawsuits challenging the authority of CMS to negotiate drug pricing. At every turn, they'll probably be challenged, right? The same is true, I suspect, for rules put out by DOL and HHS regarding things like the No Surprises Act. So, Brian, that's kind of your bread and butter, and you've been following as close as anyone has been the various cases and challenges to the final rules that have been published there. Can you just imagine how many more challenges you would see without Chevron?
I know. I can't imagine. I mean, so, the No Surprises Act, it's administered by the Departments of Health and Human Services, Department of Labor, and the Treasury, all administrative agencies. And the NSA imparts very significant rulemaking powers on the departments to enact and enforce the provisions of the No Surprises Act. And we've already seen multiple successful challenges to the various rules put forth by the departments, mainly, if not exclusively, from the Texas Medical Association, which has put forth 4 different challenges. And these include items such as the manner in which the qualified payment amount is calculated, the weight given to the qualified payment amount in IDR, the administrative fee for accessing IDR, specific issues to air ambulances. And every time one of these challenges is brought, it results in, the dispute resolution process shutting down while the departments go back and try to reassess and revamp the rules in order to try and comply with the judge's ruling. At this point, even the departments are confused about how QPA is supposed to be calculated, basically telling plans to kind of just do their best while things get figured out. An end to Chevron deference would certainly make it much more difficult for departments to administer and enforce the No Surprises Act. Parties could challenge any and all of these rules, and courts could review these, de novo, which could possibly create conflicting outcomes by circuit, which would then need to be, reviewed by higher courts. It could just create a whole mess, Brady.
Yeah, it sounds like it's a great time to be an administrative lawyer, frankly, one that's primarily litigating under the Administrative Procedures Act, because you're going to have a lot of cases coming your way in the next couple of years, I think, no matter what happens.
That's one of those be careful what you wish for, Brady.
Yeah, absolutely. Yep. And the Texas cases that you referenced, Brian, with respect to the NSA, remember, those are cases, I don't even believe Chevron was raised in those cases. I think they just believed that what the agencies weren't acting reasonably, and the courts agreed. So imagine if there's a challenge, there would be challenges to agency action where they're saying, no, the issue isn't whether they acted reasonably, but the court doesn't even have to defer right? If the court doesn't have to defer to what could be a reasonable action, you're going to see many more actions. And so, yeah, I think we're going to see a flood of cases here. It reminds me of a case we covered a couple of years ago on a webinar where I think it was the FTC tried to ban drug commercials from the airwaves entirely. And that was seen as exceeding their authority under the Administrative Procedures Act. And it was struck down. Obviously, we know there's still tons of drug commercials on TV, so that didn't work. But ultimately, what I think this is going is that what we need here and what we want to see in our industry is Congress just legislate better, right? Have clearer laws with fewer ambiguities and less omissions, and then, or better instructions to agencies. That way you don't have to rely on agencies going above and beyond. Oftentimes that's what we're seeing here. We're seeing, and frankly, whether it's administrative actions or executive orders, right? Both of those are not substitutes for legislation. And that's sort of been, I think, a slow creep in that direction where people are getting fed up with, on both sides of the aisle, frankly, agency action, depending on what it is, right, and who's doing it. So it's not going to be clean, but I think the court is likely to significantly scale back the scope of the deference that it gives to agencies in this context. And then we'll have to see if Congress steps up to respond by being clear, right, with what they mean. So I guess I'm hopeful for the future in the longer term, but it looks like in the short term, there's probably going to be mass chaos depending on what the justices decide. And like most other cases, will come down in the spring or perhaps in June, and we'll have a lot to digest at that point and let everyone know what we think is going to happen. And hopefully the underpinnings of the major laws and rules that were sort of governing our industry don't change fundamentally, but we'll have to wait and see how it goes. Any last thoughts, Brian?
These challenges, they certainly seem a little fishy, but I guess we'll just have to see what happens.
Hey, no pun intended there, given the maritime.
No pun intended whatsoever.
Not at all. Well, I encourage everyone who wants to be as tortured as I was, and perhaps others who listen to the oral argument, you can find it on YouTube. It's 4 hours long, but man, they go in some details and some pretty crazy examples. So if you want to hear more about the Chevron case, we'll also talk about it, I'm sure, in other formats on our webinar coming up next month as well. So this is not the end of the story. It's just the beginning. So with that, though, on behalf of myself and Brian O'Hara and Pat the Man Santos, our fantastic producer behind the scenes, we want to thank you all for tuning in to another edition of our podcast, and we'll see you soon. Take care.
Thanks, Brady.